All right, my name is Jake Thompson. The date is September 22nd, 2024, and this is my presentation. Injury in fact and data breaches, requirements, court standing, and obligations of companies. Data breaches are on the rise. With data breaches on the rise, there are more victims than ever. These victims want compensation. However, not all data breaches cause direct harm to those that are involved. This is why we will look at the requirements for victims to receive compensation, how the court rules on such a matter, and some obligations of companies when these breaches happen. As you can see to the right, I added a little figure showing the rise of data breaches specifically involving hacking in the red right there. The reason I chose this was to show that since more data breaches are happening with hacking, and it's not just employee error or accidental email, stuff like that, it's showing that there's more malice in data breaches, which means there's probably going to be more victims these days. All right. Injury in fact requirements. Injury in fact states that the plaintiff must have suffered, as the namesake suggests, an injury in fact, meaning that the injury is of a legally protected interest which is concrete and particularized, and actual or imminent. The reasoning behind these laws is to stop a very sue-happy public from abusing the system. For example, I can't just sue a company if my name and phone number happens to be leaked in a data breach, especially if it is already on a site like Facebook and is public domain. I did not suffer an injury in fact, therefore I don't have any claim to any kind of compensation. That's kind of the idea behind this injury in fact requirement. In Claridge versus Rockview Incorporated, the court examined the nature of the data breach, actual versus imminent harm, and increased risk of harm, and evidence of actual damages or loss to the plaintiff. It was ultimately found that a data breach in itself is not enough to have standing in court. You actually have to have evidence of harm. This set the tone for the importance of substantiating your claims with clear evidence of injury. Speaking of court standing, even though we have injury in fact requirements, that doesn't mean that plaintiffs do not have a claim. If there are records presented, such as bank statements, credit reports, physical evidence of identity theft, or even just sometimes expert testimony can get you by, the plaintiffs will surely have a case. Courts look for concrete evidence such as financial loss and identity theft, or an increased risk of harm, such as leaked information, giving potential for fraud. So this is essentially saying that you can sue for something that hasn't even happened yet. You are just at an increased risk because of the data breach. One such case that was recognized on potential future harm alone is Reed versus Village of Shorewood. This is a case where the plaintiff was arguing that Village of Shorewood did not adequately protect their personal data. The data leaked included very, very important information such as financial info, addresses, names, credit cards, bank statements, all that kind of stuff. The court recognized that there was a very real risk for identity theft and fraud here, and therefore ruled that the plaintiff did indeed have standing to sue Shorewood. That's a great case of the court saying, yeah, nothing has happened yet, but there is a huge risk of this person being taken advantage of because of that leaked data. And it was Village of Shorewood's fault. Therefore, they're liable to being sued. All right. Now, obligations of companies. Companies and agencies alike have responsibilities when it comes to data breaches. These include immediate and long-term obligations to all affected individuals. Immediate obligations are things like immediate notification, providing information about the breach, and essentially how they're going to fix it going forward, how they're going to strengthen that security. Long-term obligations, however, are actually implementing these stronger security measures and having regular audits and complying with data protection regulations such as GDPR and CCPA. Government agencies share these responsibilities. They have a little more than just the companies. The agencies focus on notification and investigation just like the companies do. However, with the agencies, they have enforcement to deal with. So they're going to be the ones that are actually going after these hackers or the bad guys. Guidance on how they're going to fix it and policy development to protect consumers in the future. I just included this little image because I thought it was, quite frankly, a little funny that they have to make a little step-by-step guide about this. Stay calm, contain the breach, assess the damage, notify authorities, notify customers and partners, and plan against the next attack. It seems like common sense, but apparently it happens a lot. So threw that in there for all of you guys. Conclusion. What is my point? All right, data breaches are on the rise. With more breaches comes more victims. More victims means more lawsuits. Injury in fact is there to make sure that plaintiffs actually were harmed and deserve compensation. They're not just contributing to the sue-happy culture in corporate America. Providing physical evidence, such as bank statements and credit scores, will give case standing in court. However, sometimes you don't need all that, and a case can stand with the possibility of future harm alone. Agencies and companies have responsibilities when there is a data breach. These include notification, investigation, enforcement, and policy changes to strengthen security in the future. Thank you very much.